Anglican Church of India filed a petition in the Punjab and Haryana High Court which has brought the state's 2026 anti-sacrilege law under legal scrutiny. The law prescribes strict punishment including life imprisonment for acts of sacrilege, particularly against the Guru Granth Sahib. But the petitioner from Anglican Church of India argues that the specific protection may violate equality under the Constitution of India. The hearing has been deferred for now, but this case could have far-reaching implications. Punjab's controversial anti-sacrilege law has now reached the Punjab and Haryana High Court. A petition filed by the Anglican Church of India has challenged the constitutional validity of the law, arguing that it provides specific legal protection to one religious scripture. The High Court, however, has not yet examined the constitutional validity of the law. Instead, it has deferred the hearing and asked the petitioner to first establish proper authorization and legal standing before the matter proceeds further.
Being a Christian advocate, every individual and every religious group is above the law, and hence we cannot give specific privileges to any particular religion. I also uphold that this will bring in anti-arbitration.
The Punjab Prevention of Offences Against Holy Scripture Act 2026 introduces strict punishments. The accused can face life imprisonment, fine up to 25 lakh rupees and non-bailable charges.
ਉਹ ਕਾਨੂੰਨ ਜਿਹੜਾ ਉਹਨੂੰ ਚੈਲੰਜ ਜਿਸ ਵਿਅਕਤੀ ਨੇ ਕੀਤਾ, ਹਾਈ ਕੋਰਟ ਨੇ ਉਹਨੂੰ ਰੱਦ ਵੀ ਕੀਤਾ ਔਰ ਉਹਨੂੰ 10,000 ਰੁਪਈਆ ਜੁਰਮਾਨਾ ਵੀ ਕੀਤਾ। ਪਰ ਇਹਦੇ ਵਿੱਚ ਇੱਕ ਪੱਖ ਜਿਹੜਾ ਦੇਖਣ ਵਾਲਾ ਜ਼ਰੂਰ ਹੈ ਕਿ ਇਹਦੇ ਵਿੱਚ ਕੁਝ ਸੋਧਾਂ ਨੇ ਜਿਹੜੀਆਂ ਸ਼੍ਰੀ ਅਕਾਲ ਤਖਤ ਸਾਹਿਬ ਜੀ ਦੇ ਜਥੇਦਾਰ ਨੇ, ਮੌਜੂਦਾ ਜਿਹੜਾ ਪੰਜਾਬ ਅਸੈਂਬਲੀ ਦੇ ਸਪੀਕਰ ਨੇ ਸੰਧਵਾਂ ਸਾਹਿਬ ਕੁਲਤਾਰ ਸਿੰਘ ਜੀ ਸੰਧਵਾਂ, ਉਹਨਾਂ ਨੂੰ ਦਿੱਤੇ ਨੇ। ਮੈਂ ਸਮਝਦਾ ਵੀ ਸਿੱਖ ਭਾਵਨਾਵਾਂ ਨੂੰ ਸਾਹਮਣੇ ਰੱਖ ਕੇ ਜਾਂ ਅਕਾਲ ਤਖਤ ਦੀ ਸਰਬਉੱਚਤਾ ਨੂੰ ਜਾਂ ਸ਼੍ਰੋਮਣੀ ਗੁਰਦੁਆਰਾ ਪ੍ਰਬੰਧਕ ਕਮੇਟੀ ਵੱਲੋਂ ਜੋ ਸੁਝਾਅ ਦਿੱਤੇ ਜਾ ਰਹੇ ਨੇ ਪੰਜਾਬ ਦੀ ਮੌਜੂਦਾ ਸਰਕਾਰ ਨੂੰ, ਉਹਨਾਂ ਨੂੰ ਪ੍ਰਵਾਨ ਕਰਕੇ ਉਹਨਾਂ ਨੂੰ ਅਮੈਂਡਮੈਂਟ ਕਰ ਦੇਣੀ ਚਾਹੀਦੀ ਹੈ ਤਾਂ ਕਿ ਜਿਹੜਾ ਕਾਨੂੰਨ ਆ ਉਹ ਸਰਬਪੱਖੀ ਰਾਏ ਦੀ ਸੋਚ ਨਾਲ ਮਤਲਬ ਪ੍ਰਵਾਨ ਚੜ੍ਹ ਸਕੇ।
I outrightly condemn this law, which has been this act, and I uphold Constitution with its all dignity and safeguard every citizen's rights. All are equal and state cannot discriminate against any citizens based purely on their religion, and therefore has to guarantee that all faiths are equally treated and no discriminatory system creeps into.
The roots of this law go back to 2015 when Punjab witnessed multiple incidents of alleged sacrilege involving the Guru Granth Sahib. These incidents triggered massive outrage across the state, leading to protest, political pressure, and demands for stricter punishment against acts of religious disrespect. Following years of debate and early amendment attempts, the Punjab government in 2026 passed a stricter anti-sacrilege law with unanimous support in the state assembly. The petition filed by the Anglican Church of India argues that while protecting religious sentiments is important, criminal law in a secular democracy must apply equally to all religions. The plea claims that giving specific legal protection to one scripture may violate Article 14 of the Constitution of India, which guarantees equality before law. It also raises concerns related to Article 25, which protects freedom of religion and describes the law as potentially ultra-wise or beyond constitutional limits.
This law is sending a very negative connotation to the entire country at large, because we belong to a rich heritage where we have citizens belonging to different religions, ethnic identities, and we have to uphold our constitutional mandate of unity and integrity at every cost.
A reason why earlier laws in Punjab struggled to be enforced was the complex legal process involving both the state and the centre. Constitutional concerns were raised over some earlier proposals, mainly regarding religion-specific provisions and severity of punishment. Since criminal law falls under areas where both Parliament and state legislatures can make laws, certain amendments passed by Punjab governments in the past required approval from the President after being sent through the centre. This legal and constitutional complexity is one reason why the issue remained unresolved for several years despite repeated political promises and public demands.
ਦੇਖੋ ਇਹਦੇ ਸੰਬੰਧੀ ਬੜਾ ਸਪਸ਼ਟ ਸਿੱਖਾਂ ਦਾ ਫੈਸਲਾ ਹੈ ਕਿ ਜੇ ਤੁਸੀਂ ਬਾਕੀ ਧਾਰਮਿਕ ਗ੍ਰੰਥਾਂ ਨੂੰ ਨਾਲ ਰੱਖ ਕੇ ਸ਼ਬਦ ਗੁਰੂ ਸ਼੍ਰੀ ਗੁਰੂ ਗ੍ਰੰਥ ਸਾਹਿਬ ਜੀ ਦੇ ਬਰਾਬਰ ਕਾਨੂੰਨ ਬਣਾਉਣ ਦਾ ਦਰਜਾ ਦੇਣ ਦਾ ਯਤਨ ਕਰੋਗੇ ਤਾਂ ਫਿਰ ਇਹ ਸਾਡਾ ਸਿਧਾਂਤਕ ਪੱਖ ਜਿਹੜਾ ਉਹ ਕਮਜ਼ੋਰ ਪੈ ਜਾਏਗਾ।
The 2015 Bargari case involving torn pages of Guru Granth Sahib and the Behbal Karan filing incident made sacrilege one of the most sensitive issues of Punjab.
ਸਰਸੇ ਵਾਲੇ ਸ਼ਬਦ ਗੁਰੂ ਸ਼੍ਰੀ ਗੁਰੂ ਗ੍ਰੰਥ ਸਾਹਿਬ ਜੀ ਦੀ ਬਾਣੀ ਦੀ ਬੇਅਦਬੀ ਕੀਤੀ। ਗੁਰੂ ਗ੍ਰੰਥ ਸਾਹਿਬ ਦਾ ਸਰੂਪ ਉਹਨਾਂ ਨੇ ਚੋਰੀ ਕੀਤਾ, ਚੋਰੀ ਕਰਕੇ ਇਸ਼ਤਿਹਾਰ ਲਾਏ ਔਰ ਕਿਹਾ ਕਿ ਤੁਹਾਡਾ ਗੁਰੂ ਸਾਡੀ ਕਸਟਡੀ ਦੇ ਵਿੱਚ ਹੈ, ਜੇ ਤੁਹਾਡੇ 'ਚ ਜ਼ਰੂਰਤ ਹੈ ਤਾਂ ਤੁਸੀਂ ਲੈ ਜਾਓ। ਅਤੇ ਗੁਰੂ ਗ੍ਰੰਥ ਸਾਹਿਬ ਦੇ ਸਰੂਪ ਨੂੰ ਬਾਕੀ ਨੂੰ ਇੱਕ ਪਾਣੀ ਦੇ ਗੰਦੇ ਪਾਣੀ ਵਿੱਚ ਸੁੱਟ ਦਿੱਤਾ ਗਿਆ। ਅਤੇ ਇਹ ਚੈਲੰਜ ਕਰਕੇ ਜਦੋਂ ਕੋਈ ਬੇਅਦਬੀ ਕਰਦਾ ਗੁਰੂ ਸਾਹਿਬ ਜੀ ਦੀ ਤਾਂ ਕੁਦਰਤੀ ਇਹਦਾ ਰੋਹ ਸਿੱਖਾਂ ਦੇ ਅੰਦਰ ਪੈਦਾ ਹੋਣਾ ਕੁਦਰਤੀ ਸੀ ਅਤੇ ਸਿੱਖਾਂ ਅੰਦਰ ਗੁੱਸਾ ਉਹ ਲਗਾਤਾਰ ਅੱਜ ਵੀ ਅਕਾਲੀ ਸਰਕਾਰ ਪ੍ਰਤੀ ਹੈਗਾ ਅਤੇ ਅੱਜ ਵੀ ਲੀਡਰਸ਼ਿਪ ਨੂੰ ਭੁਗਤਣਾ ਪੈ ਰਿਹਾ।
The Punjab government has not been able to explain why this existing law was inadequate, and neither have they explained that what is it going to provide. It is empirical basis on the claim that such laws related to one specific legislation are not required in the present context.
While supporters of the law believe strict punishment is necessary to prevent acts of sacrilege, critics argue that laws linked to religion must remain constitutionally balanced and equally applicable to all communities. Legal experts say the High Court's eventual decision could become significant not for just Punjab but also for future debates around religion-specific legislation in India. The demand for a stricter anti-sacrilege law in Punjab has existed for several years and crossed political governments. In 2016, Shiromani Akali Dal BJP government attempted to introduce stricter provisions including life imprisonment for sacrilege of the Guru Granth Sahib. Those efforts faced legal and constitutional objections from the centre and could not fully take effect. In 2026, the Punjab Assembly finally passed the law unanimously with all 117 MLAs present in the House supporting the bill.
For now, the case remains at an early stage with the hearing deferred and procedural questions still pending. But when the Punjab and Haryana High Court takes it up again, it will have to carefully examine both legal and social dimensions of the issue. As Punjab awaits the next hearing, how will the court balance the need to protect religious sentiments with the constitutional principle of equality under the Constitution of India? Camera person Hardik with Baani for Chitkara News.